Dear students, today we will learn what is doctrine of legitimate expectation. The doctrine of legitimate expectation was first developed in England as a ground of judicial review in administrative law to protect a procedural or substantive interest when a public authority rescinds from a representation made to a person. Suppose your father has promised you to give you a motorbike on completion of your course of BA LLB, but later on he refused to do so. So by promise of your father, you had a legitimate expectation in your mind that when you will complete your law degree, your father will give you a motorbike. But later on, because of financial constraints, he could not purchase motorbike for you. But you had a legitimate expectation of getting a motorbike. Similar legitimate expectation doctrine is also applicable in the field of law. Say, for example, the government of UP promising construction and allotment of 1,000 houses for scheduled castes in Noida, and later on changing the figure at 200 only. So initial promise of construction and allotment of 1,000 houses raises a legitimate expectation in the mind of scheduled caste community that they are going to have a new house which shall be allotted to them by the government. This is a sort of legitimate expectation in your mind, और हिंदी में बोले तो आपको एक वैधानिक उम्मीद है, एक वैधानिक आशा है that you will get a house allotted because you belong to member of scheduled caste. आपको वैधानिक उम्मीद है, वैधानिक आशा है कि आपके फादर आपको मोटर बाइक दिलवाएंगे क्योंकि आपने लॉ डिग्री हासिल कर ली है. In the field of law, dear students, the legitimate expectation means that a person may have a reasonable expectation of being treated in a certain way by the administrative authorities, owing to some consistent practice in the past or an express promise made by the concerned authority. According to this doctrine, a public authority can be made accountable in lieu of legitimate expectation. Thus, the doctrine of legitimate expectation pertains to the relationship between an individual and public authority. Now the question is, what is legitimate expectation? And is it your legal right? Or is it your fundamental right? So dear students, legitimate expectation is not a legal right. It is an expectation of a benefit, expectation of a relief or remedy that may ordinarily flow from a promise or established practice. Established practice is that everybody below poverty line is getting subsidy on LPG gas. And if now the government withdraws this subsidy, then definitely there will be an legitimate expectation in the mind of people below poverty line that they should get subsidy on LPG gas cylinder. And this term established practice refers to a regular, consistent, predictable, and certain conduct, process, or activity of the decision-making authority. And this expectation in this doctrine of legitimate expectation should be legitimate, that is, your expectation should be reasonable, logical, and valid. Any expectation which is based on casual or random acts, or which is unreasonable, illogical, or invalid, cannot be a legitimate expectation. Legitimate expectation not being a right, it is not enforceable as such. Rather, it is a concept fashioned by courts for judicial review of administrative action. Legitimate expectation is procedural in character, based on the requirement of a higher degree of fairness in the administrative action, as a consequence of the promise made or practice established. In short, a person can be said to have legitimate expectation of a particular treatment if any representation or promise is made by an authority, either expressly or impliedly, or if the regular and consistent past practice of the authority gives room for such expectation in the normal course. Therefore, it can be said that this doctrine of legitimate expectation is a form of check on the administrative authority. When a representation has been made, the doctrine of legitimate expectation imposes, in essence, a duty on public authority to act fairly by taking into consideration all relevant factors relating to such legitimate expectation. It also adds a duty on the public authority not to act in a way to defeat the legitimate expectations without having some reason of public policy to justify its doing so. Now the question is, who can invoke legitimate expectation? A third person who has nothing to do with the order passed by the authority. He is not affected by the order at all. Can he invoke this doctrine? Probably not. The doctrine of legitimate expectation, based on established practice, can be evoked only by someone who has dealings or transactions or negotiations with an authority on which such established practice has a bearing, or by someone who has a recognized legal relationship with the authority. Suppose a person is total stranger, unconnected with the authority, or a person who had no previous dealings with the authority and who has not entered into any transaction or any negotiation with the authority. Such a person cannot invoke the doctrine of legitimate expectation, merely on the ground that the authority has a general obligation to act fairly. The person must be connected somehow with the order. He must have some past transactions, some future transactions. If he has nothing to do with the order passed by the authority, then it cannot be said that he too has a legitimate expectation. So only affected persons can invoke this doctrine. And dear students, this legitimate expectation may arise. There are three portions. It may arise if there is an express promise given by public authority, or because of the existence of a regular practice which the claimant can reasonably expect to continue. And third, such an expectation must be reasonable. For example, if a leader of a political party makes a promise of free of cost distribution of gas cylinders to all, this may raise legitimate expectation in the mind of the people, which may not be reasonable. Because it is not possible for any government to distribute LPG gas cylinder free of cost. So legitimate expectation, even if it is raised in the mind of the people, will not be reasonable, will not be allowed. And dear students, every legitimate expectation is a relevant factor requiring due consideration in a fair decision-making process. Whether the expectation of the claimant is reasonable or legitimate in the context is a question of fact in each case. Wherever and whenever the question arises, it is to be determined not according to claimant's perception, but in the larger public interest, wherein other more important considerations may outweigh what would otherwise have been the legitimate expectation of the claimant. A bona fide decision of public authority reached in this manner would satisfy the requirement of non-arbitrariness and withstand the judicial scrutiny. Now, I'll explain this doctrine of legitimate expectation with the help of the ratio decedent I of few cases. Doctrine of legitimate expectation first found its mention in the case of State of Kerala versus Madhavan Pillai. In this case, the government had issued a sanction to the respondents to open a new aided school and to upgrade the existing ones. However, after 15 days, a direction was issued to keep the sanction in abeyance. See, now there is a legitimate expectation. Why? Because government had issued a sanction to open new aided schools and to upgrade the existing ones. So legitimate expectation arose in the mind of the concerned people. But this direction was kept in abeyance after 15 days. This action was challenged on the ground that the same violated the principles of natural justice. Supreme Court held that the sanction order created legitimate expectation in the mind of the respondents, which was violated by the second order, as the same was without following the principle of natural justice, which is sufficient to vitiate the administrative order. This doctrine was again applied in Scheduled Caste and Weaker Section Welfare Association versus State of Karnataka. In this case, the government had issued notification notifying the areas where slum scheme would be introduced. And in that area, under the slum scheme, Scheduled Caste and Weaker sections will get houses. However, the notification was subsequently amended and some areas earlier included were left out. Now see, initial order of development of slum area raised a legitimate expectation in the mind of scheduled caste and weaker sections of the society living in that area. But by second order, some areas earlier included in the scheme were left out. So Supreme Court held that when a notification is made, rescinding the earlier notification without hearing the affected parties, it is clear violation of principle of natural justice. The earlier notification had raised legitimate expectation in the mind of the people living in an area which has been subsequently left out, and hence legitimate expectation cannot be denied without a fair hearing. So dear students, here is the total summary of law on legitimate expectation. Before you, number one, mere reasonable or legitimate expectation of a citizen may not by itself be a distinct enforceable right, but failure to consider and give due weightage to it may render the decision arbitrary. Second, legitimate expectation may arise in three ways. Number one, there is an express promise given by a authority, or because of acceptance of a regular practice, a claimant can reasonably expect it to continue. And third, such expectation should be reasonable. For a legitimate expectation to arise, the decision of administrative authority must affect the person by depriving him of some benefit or advantage, which he had in the past been permitted by the decision maker to enjoy, and which he can legitimately expect to be permitted to continue until some rational grounds for withdrawing it have been communicated to him. Fourth one, if the authority proposes to defeat a person's legitimate expectation, it should afford him an opportunity to make representation in that matter. And fifthly, the doctrine of legitimate expectation permits the court to find out if the change in policy, which is the cause for defeating the legitimate expectation, is irrational or perverse, or one which no reasonable person could have made. So, my dear students, the conclusion of the doctrine of legitimate expectation is that the necessity for application of the doctrine of legitimate expectation arises when an administrative body, by reason of a representation or by past practice or conduct, stirred an expectation. You have stirred an expectation which would be within its power to accomplish, unless some superseding public interest comes in the way. However, a person who centers his claim on the doctrine of legitimate expectation in the first instance has to satisfy that he has relied on the said representation and the rejection of that expectation has worked to his detriment. And court would interfere only if the decision taken by the authority was found to be arbitrary, unreasonable, or in gross abuse of power, or in violation of principles of natural justice, and not taken in public interest. But a claim based on mere legitimate expectation without anything more cannot ipso facto give a right to invoke this principle. So, dear students, legitimate expectation is not a right, and as such it is not enforceable. But if you have a legitimate expectation in your mind, then it can bind the administrative authorities so that they may pass orders in accordance with law. Thank you, dear students. Thank you very much. God bless you.